my friend, the ranking member of this committee, Representative Scott, for his 5 minutes of questioning.
Thank you, Mr. Chairman. I yield 30 seconds to the gentlelady from Georgia.
Thank you to my colleague from Virginia. I would like to respectfully respond to comments that were made by Chairman Allen earlier that the employees are not suing and that the lawyers are just benefiting on their own. The lawyers are clearly suing on a plaintiff's behalf, so I wanted to clarify that I believe that this was just a difference of opinion between us on this issue that doesn't rise to a point of order. And I believe my comments were accurate to what we are discussing today, and I want to make that clear before we conclude today, and I yield. Back to the gentleman from Virginia.
Reclaiming my time, Ms. Dudley mentioned that 89% of the participants consider being sued as they make their decisions. Apparently it's worked because according to the statistics that the ranking member cited, 99.9% of the plans, in fact, did not get sued between 2020 and 2024. So this hearing is about the 1 out of 1,000 that I guess did get sued. Mr. Riviera, we heard a lot about these copycat lawsuits. I remember when I was practicing law, if I filed a divorce suit, each one looked remarkably like the last one I filed on exactly the same grounds. Should we be surprised that a case based on excessive fees should look much different than the last case based on excessive fees?
I would expect that there would be similarities in a lot of those kinds of cases if there are similar allegations in terms of the particular provisions of ERISA that one is challenging.
Thank you. And Cunningham v. Cornell found that the claim of exemption was an affirmative defense. Is there anything in the federal rules of civil procedure regarding affirmative defenses that is peculiar to ERISA cases that wouldn't apply to just about every other case?
Nope.
We've heard about lawyers getting paid. In fact, we heard from the gentleman from Florida that participants got $20 and the lawyers got $500,000. Raises the question, well, you can rip your participants off clearly up to $20 to avoid the lawyer getting paid. There must be some threshold where you can get ripped off. Obviously, the only way you can stop the misconduct is these lawsuits. So I guess my question is, should the plan pay the legal fees or the guilty fiduciaries who've been profiting from their misdeeds pay the legal fees?
Well, it certainly sounds like it should be the ones who did something wrong.
Okay, well, Mr. Butash and Ms. Dudley, can you name specific examples of lawsuits that were in fact frivolous that were brought against some of your member organizations?
Well, I don't think today I would name names and name specific lawsuits. I do know that there have been just a whole range of copycat lawsuits, and I'll be happy to come back to you with more specifics on these. But
okay, but if you're not going to name Mr. Butash, can you come up with examples of cases that are frivolous, and maybe even some against your members that were meritorious?
I don't have that information for you. I will say, though, ERISA reflects a careful balancing, and participants do need the right to get the benefits that have promised to them. But also, we shouldn't have a system that's so complex or so costly that it discourages employers from creating and maintaining employee benefit plans in the first place. It's a voluntary system.
Well, thank you. Mr. Riviera, can you cite examples of meritorious cases that have been brought that have stopped abuse?
So there are a lot of cases that have settled, right? And in most of those cases, well, all those cases, no one admits any wrongdoing. But you have seen, as a result of cases, changes to plan behavior that over time, as you look at the industry, have definitely led to reduced fees, greater transparency, and better choices for the plan beneficiaries.
And excuse me, if I could just add and finish my sentence, there is a good example out of the Second Circuit where the court had to revive a case based on the Cornell decision, even though they had dismissed it as baseless. So it is happening. There are lots of suits that I would deem frivolous or I would deem baseless, or courts have decided are baseless, that now will be reopened just because of the Cornell decision.
Thank you, Mr. Chairman. I yield back.